Good morning. I'm Tom Rice, and this is the House Motor Vehicles Committee full committee meeting. Obviously, we're a little light on people so far, but we've got a quorum, so we're going to move ahead. If there's anybody who wants to speak on any of the bills, please sign up. Mr. Foster over here has a sign-up sheet he's getting ready, and we'll be taking these up in the order of selection. We're pulling two bills off the calendar today. Mr. Battles wants to hold on House Bill 215. We'll not be addressing that today, and we're going to hold on House Bill 113, Mr. Powell's bill, pending a resolution of some outstanding issues, which I think we're in the process of getting done. With that, I'm going to call House Bill 127. Mr. Holt, you've been here before, and we thank you for coming back. I don't think we're going to need to see you again, hopefully.
Thank you, Mr. Chairman. When I went to ask for this bill in rules, I apparently caused a little bit of indigestion. And,
you caused indigestion here. If you remember my words when you left, I said you better have something to do with Appropriations Chairman to make sure that there's money to do this. And
yes,
obviously,
sir.
That didn't work too well. So you're back again. All right.
Yes, sir. In any case, they requested that I try to find a compromise to bring the cost of this down a little bit. And so what we're working from is a substitute LC 211105S. And basically, the original bill simply returned everything to the circumstances of a year ago in which the amateur radio community were receiving the tags and the base fee all gratis in order to get these tags out there. And so this version simply says that the actual special tag itself would be gratis, but not the base fee. And so between that and some more accurate figures I have on the actual number of potential licensees impacted, that brings the overall rough cost down to something in the neighborhood of $100,000, whereas previously I thought it was more like $250,000. And that's all the more that this substitute does, and would much appreciate a chance to go back and see the folks in rules.
Are there any questions of Representative Holt? Any questions, Representative Holt? And you're sure this is going to do it for us here?
I'm sorry?
In other words, the Appropriations Chairman has agreed, and the Rules Chairman have agreed.
And I appreciated the Chairman's tip that I should have done him that courtesy, which I did right after you gave it to me.
Okay.
A couple weeks ago.
Well, seeing no other questions, is there any discussion on House Bill 127? We have a motion on House Bill 127.
Mr. Chairman, I move do pass on the substitute House Bill 127.
Is there a second? Second. All right, it's been moved and seconded. Any other discussion? All in favor say aye.
Aye.
Opposed? Okay. Mr. Holt, you're off and running one more time.
Thank you much.
To the Rules Committee. Okay, let's just get Mr. Bowles out of the way here. 224. Let's do Mr. Amerson's bill here for a minute. This is House Bill 224. Representative Amerson, good morning to you. Chairman Amerson, I should say. Good morning to you.
And thank you, sir, for the reminder that a similar bill had run into problems a couple of years ago.
You're welcome.
And we're working from LC 211130S. This bill has been through Natural Resources and approved there, and also through the Chairman of Transportation, who was the stumbling block last time. And what this bill does is solve two problems that we have. One, it only requires a tag for an off-road vehicle when operated on state-owned property or state-controlled property. The second problem it solves is we've had some people presenting, being involved in out-of-state rodeo kinds of events, and in states that require tags, and they have been fined as much as $300, and that's where the number 300 comes from, actually, on page 2.
Right.
And so those are the two problems that will be solved. There's no requirement for a tag on private property, and the exceptions are listed there on page 2, lines 34 through 50.
Okay. Any questions of the author of the bill?
I do have one.
Okay. Mr. Battle?
Mr. Chairman, there are a number of counties that have emergency vehicles, off-road vehicles, that are for rescue purposes. Will they be required to have?
No.
Is that going to be?
They're listed under the exceptions.
Okay. All right. Thank you.
Any performance of any officer in the act of performing his duties and that kind of thing are accepted.
Okay. Any other questions of Chairman Emerson? Well, while everybody's looking at the bill, Chairman, I think that there are a couple things in here that make this a little unusual, and that is it's for the life of the vehicle, right? There's no re-up charge on the $30 fee.
Correct.
Okay. And you've got the penalty in there for not getting it. It's $300, right?
That's
for not
only
having
if
it.
you operate on
Right.
state-owned or managed property. Yes, sir.
Right. Okay. All right. And the rest of it really has to do with where it can be operated in terms of the section 6, not section, but 60A, B, and so on is just some other restrictions in terms of the capability to operate the vehicle.
Right.
It's just DNR and I assume that's a question. Mr. Powell has sidelined a question for me that says which department will administer the tagging operation?
Revenue.
Revenue.
Yeah.
Okay. All right. Okay. I don't see any other questions here, Mr. Emerson. This is fairly easy. I don't really see why we should do this so easily at this hour in the morning for you, but you're just a nice guy, I guess. He's a colonel. That's I got it. That's what makes all the difference. Okay. Anybody in the audience care to comment on this bill? DNR, or not DNR, but Department of Revenue? No comment? Okay. All right. Gee, that is really easy. Okay. Anything else? Do I hear a motion on House Bill 224? Okay. Dupass second. Dupass by Mr. Yates, seconded by Mr. Battle on House Bill 224 as substituted. All in favor, say aye. Aye. Opposed? Okay, carries.
Thank you, Mr. Chairman.
You're off and running. I understand. All right. Mr. Dixon, Representative Chairman Dixon. Chairman Dixon, come on up here. If you would, and join us. Here's 205 here. You want to do something with lemons today.
Right. Make lemonade. This is House Bill 205, LC 255731. It simply extends the lemon law protection to purchases by any branch of state or county or local government.
What was that? It's a move to
He likes
pass.
lemonade.
Second.
This must be a fantastic bill. I think you probably completed the lemonade opportunity here without Splenda or anything like that. So it's a splendid bill. No, I think it's a good bill. That's a great one to bring. The government ought to be entitled to give them back. Anybody else want to comment on that? Anybody in the audience want to comment on that? Okay, Dealers Association, anybody? That's fine. Seeing none, then there's been a move and a due pass on the bill. All in favor say aye.
Aye.
Opposed? Okay.
I like your
Thank you.
committee.
Yeah, I'll tell you what, we're easy on some and tough on others. All righty. What else do we have here? I don't see Representative Collins. Okay. I guess I've got the other ones here. Okay. Okay. And I'm holding on to Mullen. The insurance company's going to do work on it. So I'm sure you got others. They all came to me. That's fine. Okay. Well, I guess for Mr. Collins is not here yet, so we'll suspend on that one, and hopefully he'll be in by the end of the time together here. Mr. Vice Chairman, I'm asking you to take over, and we can do House Bill 269 and House Bill 309. Mr. Chairman, I would prefer to do 269 first if we could.
Sound like a winner.
All righty. And I'll be joined by Ms. Ammons. And, we have a lot of people from the department here, and I think Mr. Sean signed up to speak on this bill also. House Bill 269 is the bill from the Department of Driver Services as amended. And that's why it's a substitute. The amendments are my amendments. Basically, they come from a bill last year that we had proposed that went through judiciary. Part of it, 538, went through judiciary, and I'll talk about that later. You have a summary of the bill here on your desks as part of your folders, and I think that's what we can go by in terms of a description of the bill. Basically, this bill is kind of the annual update bill for the department, and with some things that we need to go ahead and do. Why don't we start with Section 1 on page 2, and basically all that section does is to put the current verbiage in place that talks about the alcohol and drug risk reduction program. And make sure that we know that it's not it's an assessment and intervention program. They go together, and all that it really does is make that consistent. Section 2 is one that in the current law, if you're 14 and you have somebody that's disabled or blind that's got to be in the car with you. The law is a little inconsistent in that the next paragraph down in that same section says that at 15 you have to make another change. It doesn't say anything about the 14-year-old that's already done this. All this does is to say if is that anybody 14 years or age or older this section would prevail, and that says basically that it gives the requirements for physically impaired parent or guardian or 21 years of age, and so they can go all the way up until the point in time that they get the regular learner's permit, basically. Right? Is that right? Yeah. Okay. All right. Okay. And you stop me, obviously, Mr. Chairman, anytime you feel like it. On Section 3, it's a little change that just defines who the immediate family is in terms of those people that are holding Class D licenses and are allowed to drive under them. there's been some contention apparently at the local level as to what immediate family is, and so it's defined here on line 77 through 79. There's on section 4, section 4 on lines 96 and 97, all it does is to say that there is it adds to the list of suspensions for violations this particular one that says that if it's a conviction for fraudulently obtaining a driver's license, it's to deter identity theft and fraudulent applications by undocumented aliens. So hopefully that will help us in this particular state. And all it does is really to cite another section with that felony violation in it. Section 5 clarifies the habitual violators section. Apparently there have been some issues associated with this, and from a court standpoint, habitual violators are 3 or more convictions in 5 years, and they have a possibility in the law right now of a probationary license after 2 years for a 3-year period. This basically says, look, if you get convicted again, like in the 2nd year of your revocation period, the hard revocation period, we're not going to give you a probationary license. All right? So it's another opportunity to reduce that type of activity. Section 6 is simply a cost savings measure that allows the department to send suspension and revocation notices via the U.S. Postal Services to the most recent address found. In other words, the address could be different than the one on your driver's license, and that's normally what they use to send it to, and so they're going to get the best known source of information about you to send these suspension or revocation notices. Okay, in Section 7, we're going to, the objective here is to clean up the super speeder bill from 2009 and to put the fees at, let's see, it's found on line 200, restoration fee of $310 up from $200 to $300 processed by mail, and and that goes along with all the other increases that were in the bill for super speeder. Now those dollars go to trauma care, and that, by the way, that's the only vehicle that there's any kind of trauma care opportunity associated with, since the referendum did not pass last year. Okay, that same section in Section 7 it clarifies the requirement for installing the ignition interlock device for reinstatement of a second DUI in 5 years. This is really for consistency purposes. It closes with 2 other code sections that have the same provision in it, and the requirement to have that ignition interlock device installed. Section 8, relating to limited driving permits. If you have multiple violations at the same time, reckless driving and DUI at the same time, that DDS will not issue a limited driving permit. Customer has more than 1 license suspension of violation. That's basically the way that works. And that sounds very reasonable to me. Section 9 simply removes the word sworn report, so that if a law enforcement officer is giving a citation or making an arrest in a DUI case, This closes the legal loophole that some have used, that there wasn't a notarized form. And so it's just a statement by the officer now, not a sworn statement as to the issue. If you want to comment on any of these, you're absolutely welcome to, Jennifer. Okay. Section 10 gets into additional fee changes that go along with the super speeder bill that were not done in the super speeder bill back in 2009. This has to do with the administrative license suspension, and basically it makes these fines consistent with the DUI fine. And basically, if you have a suspension, or you can appeal the suspension under an administrative license procedure, you can only appeal it for about 3 different issues, whether or not the calibration was right and some other things on the breathalyzer. So, and the person only pays this fine up to the extent of the DUI fine that might be leveled anyway. So you pay, if you have an ALS and pay $210, then it would make it consistent with the DUI change for $210 the first one. So the fact of the matter is that they're not going to pay any more. It just makes the ALS law consistent with all the rest. Okay, Section 11. Let's see, just another cleanup for the super speeder bill. And you want to take that one?
Yes, sir. The way it's worded now, if a defendant was convicted of a 4th or subsequent violation of the Georgia Controlled Substances Act within 5 years, the count of the suspensions would start over. Or there's actually room for argument that there would be no suspension for a 4th offense, because right now it's worded 1st, 2nd, 3rd, no provision for a suspension for a 4th or subsequent. So it creates the potential either that the count starts over, which is not logical, or that by continuing to commit drug offenses, the person becomes immune to a license suspension, which is even less logical. So we're just adding the words "or subsequent" so that it's consistent and reasonable.
Okay. All right. In Section 12 is a section that I added. This is the section that comes from House Bill 538 from last year. And basically all this says is that if you take a defensive driving course that's ordered by the court, this is for a point reduction or ticket dismissal purposes, it just has to be an approved course by the Department of Driver Services. The issue is that there have been several times when a judge might suggest a course to you that may be an online course out of state, or a $35 course or something like that, that really is just a certificate mill for getting your points reduced or ticket dismissal. So we added that into this. Section 13 is one where we are, excuse me, let me get to it. We're adjusting the fees for the classes. I'm going to ask Mr. Schrank to speak to this at the end of my testimony, but I'll tell you basically what it does. It moves the defensive driving course from $75 to $95, the alcohol and drug course from $25 to $35, DUI risk reduction from 82 to 87 on the assessment component, and the intervention component goes from 190 to 205. Now, you all need to also know that it provides that the schools would agree to pay the state $5 for each one of the defensive driving and alcohol and drug risk reduction courses that they take to offset the cost of maintaining the audit for them and things like that. That doesn't mean that money goes into the hands of Commissioner Dozier for expenditure. All it does is say the state gets money into its coffers effectively that hopefully would be allocated to that purpose. Okay. Now there are. I'm going to ask your indulgence here because it was pointed out to me that there are some amendments that should be made in section 11. I'm going to point the line number out to you. Excuse me, not 11. This is 13. Section 13. This is on line number 418 and 419. 419 calls for an advanced defense driving course or a professional defensive driving course. Those things don't exist at this point in time. There are no advanced courses or professional defensive driving courses. So the code section should be amended to take out the word either on line 418 and take out the words, take out everything after course on 419 and put a period after course and then start with clinics on 420. Readjust the numbering. Another change is on 435 and 436. This is something the committee needs to really, I think, take into consideration and understand. This is the defensive driving clinics. And it currently says clinics may be operated by any individual, partnership, corporation, associate, civic group, club, county, municipality, board of education, school, or college. Now, I would request that you consider an amendment on 435 to remove everything after corporation and put a period and a quotation mark at the end of corporation. Take out association, civic group, club, county, municipality, board of education, school, or college on the defensive driving course. And the reason is that we have put these schools into business, private schools into business, and they provide this service across the state right now. And basically, these other organizations are using their capability to offer these courses as just adjuncts to what they currently do. And I don't find it to be a good idea for a college or board of education or anything like that to concentrate on anything except what they're supposed to be teaching, and not necessarily to get into the defensive driving business just to make $100 a kid. My understanding is that DeKalb County just initiated a program for defensive driving that would be provided through the schools, which is $100 a child, which is more than what this bill calls for in terms of the $95. So I'd make that in the form of amendment also. And the last one. Another change would be on line 447 on page 13. And this is just the wrong nomenclature in the current code. It says the commissioner shall be authorized to issue a special license to the instructor of any commercial driver training school to teach the alcohol drug course. We want to change that. Shall be authorized to issue a special license to a instructor licensed, or an instructor licensed under, licensed instructor of a driver training school. Commercial driver training schools don't teach alcohol and drugs, so that's not a correct use of the code at that point in time. It's clean up language. The last change I would ask you to make is on line 455. The sentence is any text or workbook provided or required by the Department of, it says public safety. It really should be driver services. And so it just changes public safety to driver services. Okay. I hear people getting restive behind me here, so I guess this bill's getting a little long. There's another cleanup language in section 14. It just says, it takes out the word advanced and puts in approved. The reason, again, is there's no advanced course, so it's just cleaning up the language. Section 15 provides for the issuance of free honorary ID cards. If you have you get an honorary ID card if you're the spouse of a veteran or somebody like that. You get a free you get a free license. This is to say, if you want an ID card, we'll give that to you free also. The department makes that recommendation of that change just to be consistent. It also provides a discount for those people using an online system to transfer from a driver's license to an ID card. Again, negligible impact, but a nice thing to do for the customers when they get the online for using the online system. Should result in less work for the department. Section 16. We did a lot of work on texting last year. This simply adds on page 17, line 563. It adds the fact that it makes it effective with federal law that if you're a CDL license holder, you can't be texting, and adds it to the list of serious offenses. And this is required by federal law. I say that it's actually required in early 2012, which will be before the session starts. So we'll not have any chance to be in compliance then. So this is getting us in compliance now. Section 17, mandates submission of medical information by CDL holders. Again, a federal law change. Section 18 changes the term for ID cards for disabled from 4 to 5 years. Allows for internet removal. Again, that's cleanup language. Section 19. It just allows the department to use other methods to identify people in background investigations other than fingerprints. There are some situations where the digits are not recognizable, and they've had chemical exposure or whatever it might be. There are things that there are other ways that they can do a background check, and they just want authorization to do it that way. Okay, Section 20. This has to do with the ignition interlock device. Why don't you handle that one, Jennifer, at this point?
Yes, sir. In the current law, there is a provision that allows for judges who are entering sentences in a second DUI or a second or subsequent DUI case to grant an exemption from the ignition interlock requirement if the defendant in that case would be subject to an undue financial hardship by being required to install the ignition interlock. Because of the way that the code is written, the defendant would not be eligible to install the interlock until at least a year had passed since the date that they were convicted of that DUI. The current provisions of 401332 and 401333 state that the court loses subject matter jurisdiction to change its sentence after 6 months. So we essentially have customers who find themselves in the position of 6 months after the court can do anything to help me, I need the court to help me. And so this is actually something that has been identified in our conversations with the municipal court judges, the probate court judges, and the state court judges statewide, where if they were legally authorized to make those changes to the sentence more than 180 days after the date that the sentence was entered, they would be able to help people who are in legitimate financial straits where they cannot, for financial reasons, have that interlock installed. Typically it's because they just don't own a vehicle anymore.
Okay. Coming down to the end here. Section 21 is an amendment that I also offered, and all it does is raise the surety bond for the schools, for the driver training schools, from $2,500 to $10,000. It costs $100 to do it. It's the same price as it would be before. For $2,500, you don't really have to pay any more for the $10,000 bond. This is just in case somebody decides to go out of business with people who have attended these schools money in their pocket. And don't complete the contract with them. It gives them a little more leverage to be able to do that. And frankly, it's not inhibiting anybody from doing business unless they really have a bad credit rating to start with, which probably is not somebody we want in this business. Let's just see, 22. Oh, this basic section 22 is again consistency language. It's an additional code reference to section 13, which is that $25 to $35 change for the alcohol and drug course. It's just a different section of the code. Isn't that right? I think that's right. It's not for you. No, that's right. Okay. And then section 23. Really all this is saying, if you're going to teach a driver education program, you're going to get an opportunity to pay the department $5 per person for that privilege. The schools can adjust their fee to cover. On that score, by the way, schools are still authorized $150. Excuse me, the person who takes that course still gets the opportunity to take a $150 tax credit for driver education, plus the insurance reduction will more than pay for any change in this particular section of the law. The rest of it basically is the effective date and upon governor's signature language. And that's the presentation of the bill. Sorry it took so long to do that. I guess I have more words than I need in many cases.
Quite all right. We have a question. Would you rather wait until we finish all the testimony, or you want to go ahead?
Yeah, I'm on. There are a number in several places of increases in fees regarding super speeder. These fee increases range from 47.6% in one case to 50% in the next in multiple places. It's my understanding that no fees have gone into any trauma care that have been generated from the super speeder law since we passed it. Is that correct? Do you know?
I don't. Well, the appropriation for 2012 is not done, and these things just went into effect. The amended budget does not carry that we voted out. Does not carry anything, and I am unaware of the other appropriations. I don't sit on those subcommittees, so I don't know what they're doing with regard to trauma care. My guess is, like other things that are involved with this, that probably could be used for education or something like that.
Well, see, and the thing that bothers me, I guess, most about that bill, and I don't mind telling anybody that I voted against it, simply because there wasn't any provision that was in the super speeder law that forced those funds to go into a trauma care fund. And so I guess my request is that the committee and the author would consider at least tying these fund increases to be predicated upon those funds going towards trauma care. And if they're not going towards trauma care, then they're just going into the general budget. And then and I think we eroded a lot of public trust on that super speeder bill when we said we were going to fund trauma. And I think that's one of the reasons that we saw trauma care fail.
If that could be done in law, I think that would be a wonderful thing to do. I think the Constitution, though, requires that if you're going to earmark those funds, it has to be done by constitutional amendment. And so the only option there is to really form a constitutional amendment, which is what Senator Goggins tried to do last year, which went up on the ballot and was roundly defeated. So this is the only vehicle that there is to have any opportunity to state that it's the intent of the legislature that these funds would go to trauma care. I agree with you. I mean, if that's, if they're not going to go there,
appropriating them for general fund balance.
Yeah. You care to comment on that?
I can't speak to the appropriations process, obviously, but the only reason that the department included these in the bill was for consistency. As we went through and have been implementing the provisions of House Bill 160, these were reinstatement fees that were not raised at the same time that House Bill 160 was written, that in the interest of consistency, should have been. For example, there's language in House Bill 160 that says if you get, let's say, a second suspension for hit and run or fleeing and attempting to elude, your reinstatement fee is $310. It seemed inconsistent to the department not to do the same thing for DUI. And that's one of the oversights from House Bill 160 was basically we just missed it. I missed it because I was the one that identified those. So I'll take that one as my mistake. It was something that I missed, and so I'm trying to rectify that in this language. It is not logical to me that the reinstatement fee for a second hit and run should be $310, but the reinstatement fee for a second DUI is only $210. They're in the same code section. DUI is arguably more serious.
Then a hit and run?
I'm sorry?
Then a hit and run?
Yes, sir. That's what it says right now. It's a more serious offense, and it should carry at least the same reinstatement fee. So this is not taking a position about trauma care or anything. This is simply to make the code, as we administer it, consistent.
So we could do the same thing and reduce the hit and run down to the $210 rather than raise the other one up.
That certainly could happen, but then that money could not be appropriated for trauma care.
Yeah, and it hasn't been yet anyway, which is my point to begin with.
You may wish to make an amendment. Do we have any other questions from the committee at this point? All right. Do we have anyone else who wishes to address the bill? Mr. Frank? Try that one. No.
Since it's going out over the internet, you need to.
Good morning, Mr. Chairman, members of the committee, ladies and gentlemen. My name is Barry Schrank. I'm president of Taggart's Driving School. I also represent the Georgia Association of Risk Reduction and Defensive Driving Educators. And I am here this morning to speak in favor of the bill, House Bill 269, Chairman Rice's bill. There's basically two sections, one that affects the Department of Driver Services. We support those changes that are needed. A lot of times there's difficulty clarifying the bills and administering it, or clarifying the law and administering it properly. And I think this solves a lot of problems. With respect to the DUI schools, which are separately licensed from the driver improvement schools and separately licensed from the driving schools, we think these changes in the code section would be beneficial to all concerned, both the general public and to the school owners. We spent a lot of time. I think Chairman Rice has explained all the different sections. If anyone has a question about any specific question, I'd be glad to try to answer it.
Any questions?
Page 13 of the bill, in lines 435, 36, and 37. When we start talking about driver improvement clinics, I'm assuming that's just straight driver education in certain cases and doesn't have to be for, impaired driving or DUI schools or something along those lines. Is that correct?
This refers to the 6-hour defensive driving course. It's a separate license from the department to operate that. The instructor has a separate license, and they have to follow one of about 5 approved curriculums. And the majority of people who take that 6-hour defensive driving course take it because they've gotten a moving violation, and the court will allow them to take that course, turn in the completion certificate, and in many cases they'll non-process the ticket. So the municipality still gets the court fees. The individual doesn't have to appear in court. The police officer doesn't have to come off the road to prosecute it or act as a witness. And there's a lot of municipalities who follow that process.
And to the chairman,
I think you were talking about the alcohol and drug, were you not?
well, I'm just trying to figure out exactly what is being. Do some counties or some municipalities in that list of language that you want to amend?
Okay.
Do certain counties and/or municipalities have and administer these types of clinics?
You're talking about for the defensive driving course?
Yes, sir. Whatever this is being referred to.
That's my understanding, yes.
And so if we limit it to, if we put the period in your amendment to individual, partner, or corporation, period, I just noticed that association, civic club, county, municipality, board of education, those get left out, and I wonder if there are any existing municipalities and or counties that are administering this presently.
I'd have to defer to Mr. Schrank, the association.
To my knowledge, there aren't any associations, civic groups, or clubs that operate any driver improvement clinics. There may be some counties and municipalities, and I know there's a Board of Education that operate these clinics, but they're unlicensed.
In other words, they don't come under the Department of Driver Services.
I can give you an example. You've got a speeding ticket, and you go to court, and the judge says, there's a friend of mine in the back of the courtroom, and he has a defensive driving course on Saturday morning. Go back there, see him, take the course, bring the certificate back to me, and I will reduce the fine or dismiss the charges, what have you. If I were sitting back there, which I can't by law, but if I were sitting back there, I would tell them the cost of the fee for the course is $75. You have to show up at a certain time, take a test at the end of the 6 hours. There can be a monitor from the Department of Driver Services that could sit in on the class to make sure it started on time, that you were not left out early, and that we followed a certain curriculum. The other person might say, meet me at my house on Saturday at 9 o'clock. The course is 3 hours. It's $250, and we'll give you the certificate at noon time.
I think the other on the fees, the other issue on the fees, really adjustments that we've made. These fees haven't changed for over 8 years, from what I understand.
Any other questions? I might help to clarify, maybe for the members of the committee here, to talk a little bit about. Give me the latitude. We've over the years that I've been on this committee, years ago we saw the need, because of the partnership that had developed over a period of time between the private industry that was doing the 36, the drug testing, or the drug courses and such like this, that we had an investment in these schools to be sure that, one, that they were doing a good job, which meant that they weren't taking money, cutting the hours of the course, and they were very diligent in that. And, you know, Chairman Rice just made a comment, and I hadn't realized it had been that long. It's been 8 years since any of these courses that these schools have had an increase. And I think it's incumbent on this committee to be sure that even though they're licensed, and hopefully because of this language in the bill that will, and I'll address that in a minute about some of these other courses, that we be sure that these folks stay in a financial footing, that they are making a profit. Because it was always a concern of myself and other members of this committee historically. Once upon a time, there was such a thing as selling licenses. And that was the reason things have become so rigid over the years, to be sure that those courses that are licensed by the state and DDS that administers this, they do these periodic checks to be sure that these aren't diploma mills and the such as that, both in the DUI courses and in the driver improvement courses. And I think it'd be incumbent that we look at that. Now, that being said, since it's been so many years, I'd ask the chairman, do you feel very good about these? These seem to be very minimal increases.
Mr. Chairman, I appreciate the question. That's basically what the industry has asked for, and they feel like they can make profit doing it that way. They also point out that if you compare that to the price of the ticket that you're going to pay these days compared to what it was 8 years ago, just that fact alone show them the expansion of the cost to the person who's driving a vehicle, might want to go to one of these schools. So, well, I think the inflationary nature of just the cost of materials and the instructors, keeping people in the car, the cost of the car themselves that they've got to put into their profit and loss statement, this is certainly a minimal charge, and frankly, with them paying $5 to the state for the opportunity to do this, I think is more than fair.
And I think that's where my concern is that one, that these schools have not had any increase in 8 years in any of their fees. And as I look through the bill, of course, DDS and some of the bills that was passed last year, dramatically increased the penalties on offenders. And as I look at these fees don't seem to reflect enough, given the situation of what it costs to do business, what the rents cost, what the utility bills cost, and those to keep these schools in good stead. And I'm just curious whether we really think that we're even increasing or giving them a periodic increase enough to even cover what they should be reimbursed, at least ways through this sector. I'll say another thing in response to one of the sections that Chairman Rice, and I know that it was a slip of the tongue by Mr. Shrink. He didn't mean that judges sit on the bench and refer folks to their friends in the back of the room. But I will tell you that this is an age-old problem that this committee has had and looked at it, and it didn't just start in the last near future, that there are courts of jurisdiction who will tell offenders that they will lower the offense or do certain creative things from the bench if they take a course. And that course should not be mandated who is teaching a course by a judge of a jurisdiction. That's the duty of Department of Driver Services, to be sure that those courses are legitimate and it gives credentials to them. And I commend you for addressing this issue. Questions? Do we have anyone else that wishes to address this bill? Commissioner, good to have you here today. Would you like to speak on this bill?
No, sir. I think you guys have done a great job. Be happy to answer any questions, obviously.
Colonel?
We support it, sir.
We have our friend from GMA.
Mr. Chairman, Lamar Norton, I'm with the Georgia Municipal Association. I heard you're deleting the associations and the cities and the counties from teaching defensive driving, and yet we have a mobile simulator and a joint effort we do with ACCG that we go around and we teach anybody driving a city or county vehicle defensive driving. It's a certified program. It's a very good program. We've spent tons of money trying to put this thing in place. I hate to see us take something away that works so well, because we lower liability costs, we lower taxpayer costs with this thing that we've got. And I really would appreciate you reconsidering that, taking us out of that loop.
If you'll stand right there a minute. Can you address his concerns?
It's not. That's not her language. That's my language,
right.
Mr. Chairman. And that's found on page 13 again for the committee's purposes, and that's on line 435. It's the same issue. It was brought up before by Representative Austin. I think you ought to give Mr. Schrank an opportunity to respond to this on behalf of the schools. I'd be okay with existing schools being grandfathered in to this.
Lamar ask you a question.
Yes, sir.
The course that y'all teach, I mean, this is for what? This is.
It is the 6-hour defensive driving course. We have a simulator, a mobile simulator that we carry around to each city or county, and we set it up, and we get as many people to take that 6-hour class. It's an effort to try to lower liability cost for our cities and our counties, and it's very successful. It's not some Johnny-come-lately program. This thing is actually has been certified and approved across the state, and we've had hundreds of policemen, firemen, EMS, meter readers, anybody driving a city vehicle that feels like they need this class, we put it on for them.
But these classes by GMA and ACCG in coordination, this has no effect other than training your own personnel
Yes, sir.
or lower insurance rate?
It is to train our people to drive defensively and safely.
So is this, but it would not be a course, it would be issued, say, at a court, that say if a court.
I'm not aware of that, Mr. Chairman. I can't answer because I just don't know that to be true.
Thank you, Mr. Chairman. We were told that there were not any other courses being available outside of the corporate structure that's being proposed here. Now we find we do have. In extending some kind of grandfather clause, Chairman Rice, would we possibly be opening the door to some that we would rather not continue that's operating in the state? I fully support what you're doing and hope that we can continue to do that, but to somewhat grandfather those that are already maybe operating those within the state to continue that might be a little dangerous. Either one of you respond to that?
I certainly I'm only familiar with the one that we do jointly with ACCG, and I stand by that program. It's a great program. We've got a lot of money invested in our simulator, and we've got a staff of about 6 people that put this thing on, and it works very well. First class training school, and I would hope that we could get some consideration not to do it. As far as other classes that are out there, I'm not familiar with them, Mr. Battle.
Sir, and you want?
Yes, thank you for giving me the opportunity to address my friend Mr. Norton's concern. Basically, the program that he's teaching is licensed under, not even licensed, but it's under 33-9-42 or 43, and that's in the insurance code. And basically, in that code section, it says that organizations such as ACCG can teach a defensive driving course to their employees. So this bill in this code section would have absolutely no effect on Mr. Norton's operation, which I support. The certificates that he issues, if he issues a completion certificate, can be used for insurance reduction, even the employee's insurance reduction, let alone the county or the municipality. But it can't be used for points reduction. They can't take that certificate to the Department of Driver Services and have 7 points taken off their license, which they can with our course once every 5 years. And I'm sure that they're not taking those certificates to a judge for a ticket dismissal. So really, we're talking 2 different programs, and if this change passes, it will not have any effect on Mr. Norton's programs or any similar programs throughout the state.
Could now, Mr. Norton, would you have any heartburn as to this?
The heartburn I have is when we say we're eliminating certain people from teaching the course. It depends on who's looking at the code section and which code section they look. I don't want someone to get mixed up and say, well, wait a minute, you guys can't do that. We end up in court somewhere trying to defend our program when we've got an outstanding program that does work. And certainly not to be argumentative with anyone, but we've got a very effective program, and I would hate to see there be the possibility that somebody would think we were eliminating that program.
But and I'm sorry, Mr. Chairman, I just follow up, but you are presently operating under this code section that has to do with the insurance industry, right?
We are operating under the insurance code.
Okay, so you're protected as you are right now under that code section.
I would have to rely on my general counsel, who's not present in the room, to tell me that, but I don't know that to be true.
Okay, thank you.
Lamar, if I might ask again, but the program in general that y'all and ACCG co-op together, this is really for insurance reduction and not for any points, which is not eligible to classify for any points violation for any city employees or anything.
No, I'm not aware of that, Mr. Chairman, at all.
Mr. Chairman, I think Legislative Council has some language that may help.
All right. Rick, question?
Yes, thank you, Mr. Chairman. Before we get into the crafting of new legislation or language for this, my concern along the same lines is for boards of education, school or college. When we start talking about the Regent system or anything else, we've got some really big institutions out there with a lot of fleet. And I know that, for example, at my institution, we do take opportunity to train our drivers, because they're driving either, buses or vans or college and university cars that may be going, great distances, et cetera, and so forth. And we do get a reduction. And so I think perhaps if we could craft it in some way that we're talking about not a points reduction, but rather a in-house training clinic, et cetera, and so forth, utilized to promote safety within your own organization. Something along those lines, I think, would accomplish what we're looking for without getting into the for-profit issue that you raised, because I don't think that people, you raised some very quality arguments about who gets in for for-profit and who doesn't, perhaps.
I think the idea was to change this so that after corporation, it says the amendment would say that, notwithstanding this clause, insurance reduction programs teaching the defensive driving course qualify under 33, whatever the code section was.
Exactly.
Thank you, Mr. Chairman.
Mr. Yates.
My concern was that to be sure that GMA and the County Commission Association could continue to do this. I don't know, is language necessary in that to do that?
Yeah. I think it would make it clear that they are absolutely in this and they can teach it, which is authorized, as I understand it, in 33, that they are authorized to teach it, and it's for insurance reduction purposes, not ticket reduction, ticket dismissal or point reduction.
Thank you. If I might ask, Lamar, to our friends with the ACCG and GMA, would y'all have any heartburn with that type of amendment? We reference the proper code section under the insurance clause.
I'd feel much more comfortable, Mr. Chairman, if you did that.
Very good. Any other questions? Do we have anyone else who wishes to address this bill, either for or against? Well, then that being said, then what's the pleasure of the committee?
Mr. Chairman, if I may make sure that the Legislative Council got the amendments that I offered during the course of discussion.
Well, we need to move on the bill, and then we bring forth all the amendments.
Move to pass on House Bill 269 as amended.
As amended. Mm-hmm. We have a second. Further discussion, and this would be the proper time for the amendments. Well, then I will be the first one. Let's amend this section to put the proper language. Rick, have you got something crafted?
Yeah, I think we could
push on.
have line 436, which are now in with the period in the close quote after the previous amendment. Nothing in this paragraph shall be construed to limit, for insurance reduction purposes, any program established under the terms of code section. It's 33-9 I don't have it in front of me, but I will put the proper code section in there.
Would you like me to take the rest of the amendments, Mr. Chairman?
Yes, sir, if you don't mind. Is everybody in agreement, understands that amendment, and has trust in Rick, which we all do, that he'll put the proper section in there? All right, that's one. Yes, sir, Mr. Chairman, go right ahead.
Second amendment would be on line 418, section 13. Remove the word either, and remove all after course on line 419 and put a period after course. Are you going to vote these individually, or are you going to vote them all at once?
What would be the pleasure of the committee? unless there's another one that comes out to delete super speeder language in trauma care. All right. Yes, sir. Go ahead, Mr. Chairman.
Okay, the next amendment would be on line 447, and it would insert an "and," remove "the," remove "of any commercial," and insert in its place "licensed instructor of a," and a driver training school. So it should read, the commissioner shall be authorized to issue a special license to an instructor license, I'm sorry, I said it wrong, Mr. Chairman. Remove instructor also and just say special license to an licensed instructor of a driver training school to teach the drug and alcohol course.
Rick, you got that?
Yeah.
All right, next.
Okay, I believe the final change, final change is on line 455, and that's to remove the words public safety and insert driver services. Mr. Chairman, I make that in the form of an amendment.
All right. You have any other amendments, Mr. Chairman?
I don't have any other amendments, Mr. Chairman.
All right. Let's deal with these first and see if there's anything else, since these seems to be. Do we have a motion to accept that as a group of cleanup amendments?
So moved.
We have a motion. Do we have a second? All in favor say aye.
Aye.
Opposed? All right. Now, do we have any other amendments that seems to be bearing on anyone?
Mr. Chairman, I know we've had a little bit of conversation about the fee increase for the super speeder aspects of it. I would like to query the other members of the committee, including our distinguished chair, their feelings about equilibrating these fees up or down. Am I the only one that has any cause for concern?
Give us a line number.
Line 200, 201. And then lines 350 and 351.
Would you like to address these?
I'm asking if the other committee members have any thoughts about this.
I'm not the right person to be asking that.
Mr. Chairman,
I didn't vote for super speeder, and I ain't real keen about a lot of the fee increases that's gone into effect.
Mr. Chairman, if it would suit the pleasure of the committee, I would accept a friendly amendment to restore the original language on those areas, on those DUI charges.
Thank you, Mr. Chairman.
All right. Would you like to do this in the form of a motion?
I so motion.
That would be on line 200 and 201.
200, 201, and 350.
To remove the strikeout on 210 and strike out 310, to remove the strikeout on 200 and strike out 300, and on 350.
Same things.
Rick, would you take a good look to be sure we're...
Yeah. But I believe that if
Speaking of fees, does anyone know how much has been received since this super speed has started? I know I should be careful, as Gene Talbot used to say, them lying newspapers, but I read an article. That said that some judges on the super speeder were asking the police to lower it 1 or 2 miles per hour to keep from hitting some of these people with so much money. I don't know whether it's truth. I just want to know how much money has come in on it. Does anybody know?
Leave that to the department.
Yeah, how much money has come in since the governor asked us to put in the super speeder bill?
Commissioner
I
Dozier?
don't know that number. I can see if
We have, there's 2 sections of the super speeder. There's a $200 fine fee that was added on for super speeder, and then there was an increase in the reinstatement fee. So I'm going to give you the 2 different sections. I don't have the total of them together. But as of January 2011, under the $200 fine, the state has collected $5.6 million, and under the $200 fee, make sure I have this. I'm sorry. Under the $200 fee, the state had collected $5.6 million. Under the enhanced reinstatement side, the state has collected $1.9 million. So the state at this point has collected just under $7 million. The projections in the revenue projections for this current fiscal year is $10 million. Next fiscal year, if you look in the governor's budget recommendation, is $16 million, to give you an idea of the projected revenue collections for the current year and next year.
That sounds like everybody out there is super speeding never that much money, but none of that is going to trauma care, I take it, huh?
What is the reinstatement fee, Greg, again, for the
The
committee?
reinstatement for first is $210, second is $310, and subsequent would be $410. And then depending on the violation, it could have been different. Most of them were 200 flat, but there were a few that were different prior to House Bill 160 last year, and this basically made them more consistent. There was one exception, a failure to appear, and that's basically non-payment of a traffic citation. The reinstatement on that one went from $30, I believe.
$35.
$35 to $90. So 210, 310, 410, and then $90 on the failure to appear was the changes in House Bill 160.
Was that more or less than anticipated when the governor proposed that, do you know?
It is less. Initially, I believe around 23 million was believed to be brought in, and 16 million is projection for next year. That will continue to climb. The major difference in it is that reinstatement fee, as you know, is not, you pay a fine when you get caught with a violation, but the reinstatement is if you want to be back in the community that drives. What we're seeing is that right now, probably based on the economic situation, people are not reinstating as quickly as was initially anticipated. Therefore, the projection was higher than what the collection would appear to be, which is around 16 million is what we're believing is going to be collected at this point when you look at both of those combined.
Thank you.
Mr. Chairman, Mr. Commissioner, if you don't mind, I just want you to understand that I don't have a problem using fines levied to deter egregious behavior, particularly behind the wheel. And I want to tell my folks from Georgia State Patrol and other law enforcement agents here that that's not my intent. But I think you can see when we've made a public promise that we're going to put X dollars into certain funds and we haven't done that, it leads to folks kind of raising their eye, wondering what we're doing down here. And so that's the reasoning for my questioning. I think other members' questioning as well.
Yes, sir, I understand completely.
Mr. Chairman, there is one other place that this fee increase took place, and that's on 362 and 363. If you put it back to the original language, the prescribed restoration fee, it has been changed to restoration fee of $410 and $400 processed by mail. That fee is currently $200. So I would offer that in the form of amendment that the original language on 362 and 363 is restored.
Mr. Rick, do you have all of these?
Yes, I do.
The committee understands what all of these sections. And we have a motion. Do we have a second? We have a motion and a second. Any further discussion on this amendment? If not, all in favor say aye. Aye. Opposed? All right. Do we have any other amendments? Any other discussion or questions? We have a motion on the bill as amended and a second. All in favor say aye.
Aye.
Opposed? Thank you, Mr. Chairman.
And that's as substituted.
As a committee substitute.
Thank you, Mr. Chairman. I appreciate that. And thank you to the good people at DDS. By the way, for the committee's benefit, both the commissioner of DDS and Ms. Ammons have won national recognition for their work in driver services across the country. And so I appreciate all the work that they do over there.
Thank you, Mr. Chairman. And as a commentary from this temporary chair up here, for the committee members' benefit, I would like to say that while this is, and I echo what Chairman Rice had said, DDS has done an excellent job. They're doing a good job, far better than they've progressed over the years. But I will also say this as a word of caution to the committee. Historically, fines, reinstatements and all were always considered part of the process to try to let those type of financial issues bear onto the type of the offense. And we're fastly coming to the point with traffic fines and reinstatements to where we have become in the criminal justice system. We're not just locking up people that we're afraid of. We're locking up people that we're mad at. And quite frankly, this is where we're going. We know that for a fact historically that a lot of people, every time they lose a driver's license, quite frankly, it's getting to the point where some of them can't even afford to get their license back, the affordability. So a lot of them are driving without a license. And those are the people that scare me even more.
And insurance.
And insurance.
Thank you, Mr. Chairman. Joe.
Second bill?
Yeah. The second bill, Mr. Chairman, I hope doesn't take as much time as this, although there's some people to speak up on this bill, and I think you might want to hear them. House Bill 309, LC 342923, is the bill we're working with. Basically, this has to do with scrap vehicles. A couple years ago, we put in place a process whereby scrap vehicles could more easily be taken effectively off the road. The blight that was occurring with these things, and particularly where there was a situation where there was no title stream and ownership was not easily provable. And so what we did at that point in time was to institute the law that we're amending today. What we said was at that point in time, if the vehicle is 12 years or older and worth less than $750, they could, by affidavit, effectively transfer that vehicle to a salvage or scrap or parts dealer. That process is working very well, and this bill is really simply to clean this up a little more and to help the law enforcement people at the same time. A couple things I'll point out to you. On line 18, on page 1 in section 1, we've raised the value for scrap from $750 to $1,000. That's to account for the increase in scrap prices. It's also to account for the fact that there are bigger vehicles like pickup trucks and things like that that have more value and have more scrap associated with them. So there was a desire to raise that threshold. My understanding is that the parties to this bill who have an interest in the bill have settled on a value of $850 as a compromise to ensure that the interests of the used car dealers and the association responsible for salvage would be in accord. And I'm okay with that change. Let me just go over to the the bill itself, I'm not going to say a lot about the process here except to say that what it does is to automate the process. Right now, they're required, salvage dealers are required to report within 72 hours by paper the salvaged vehicles and effectively the information that goes along with them in terms of the information available on the affidavit. This changes that. This changes that to 48 hours, and it requires that this to be done electronically. And the great thing about this is, and I think you'll hear from the Atlanta police and some others, is that this is going to give them a much better ability to catch stolen car situations right up front. And before the time exposure, by the fact that it's all got to be keyed in over again, is taken into consideration. Just remember that anybody that keys this in the Department of Revenue right now has got to key the VIN number correctly, and has got to key all the rest of the information correctly, and that allows itself for a lot of errors and a time delay in terms of this happening. So this is going to help the scrap dealers move their process forward from a business standpoint. It's also going to help the police catch guys who are trying to scrap stolen cars, and I think it's an overall good change for this whole area. The bill itself, when you take lines 50 all the way through 97, is really about the process. And the other part of the process I want to bring to your attention is when the paper document is sent to like Gwinnett County or Fulton County or another county type of thing, that information is only available in that particular county. So if this crosses county lines, jurisdictional lines, that information is really not known. And so, again, the ability to have a central repository of this data, it would be good. Yeah, by the same token, this information would be electronically reported to MVDIS, which is the National Motor Vehicle Registry, and that would, again, allow them to take out-of-state vehicles and know what the situation is with them, whether they're stolen or the interest from a scrap standpoint. So without going into the specific reporting details of this and what's required in terms of the identification numbers and so on, that's basically the context of the bill. I think it's a great bill. I think it's going to do a lot of people a lot of good, and I'll let the other people who want to comment on it do that, Mr. Chairman.
Do we have anyone who wishes to speak?
You got a sign-up sheet, I think, Mr. Chairman.
Members of the committee, I'm Steve Levitin. I'm Senior Vice President of Pull Apart LLC. We're a discount do-it-yourself used auto parts retailer. Means we handle junk cars. And we are headquartered in Georgia. We have 4 locations in Georgia. We have 23 total, and we're operate in 10 states. In 2007, as Chairman Rice mentioned, we took a leadership role in effectively dealing with these older, what we call end-of-life vehicles. And through the passage of House Bill 171, we put in place a mechanism that allows these vehicles to legitimately be sold and scrapped or parted out, and for there to be an adequate information trail for those vehicles, really for the first time. And I'm proud to tell you that the system that was put into place in 2007 in Georgia has now been replicated in many states surrounding Georgia. The bill that's in front of you today is the result of a joint effort between the industry and law enforcement, and we've been working together for the last 6 to 8 months in the development and crafting of this legislation. We found that there were a couple of shortcomings, a couple of issues that needed to be addressed. One was the ability to get information, for law enforcement to get information on those vehicles that are being scrapped. We as a company provide that information to local law enforcement in the jurisdictions in which we operate on a daily basis. Well, we do that voluntarily. There's no requirement to do that. Many others in the industry also do that, again, voluntarily. But it's not uniform. And as Chairman Rice said, the problem is that information is then not available across jurisdictional lines. So one of the things we wanted to do was to create a statewide database of this information, and then to allow for that data to be transmitted to the state electronically. Again, this is sent in manually. Those forms that we send in then have to be individually entered. We're seeing significant delays between the time that information is sent in and it's actually entered into the state's systems. So those two elements of this bill are the prime changes. There's a final issue, and that is the federal database, the National Motor Vehicle Title Information System. Was put into place, became effective in March of 2009. That's the result of Congress passing the anti-car theft bill in 1992. So merely 17 years after the passage of that legislation, they implemented this provision. And it puts requirements on both us as an industry, but also on the state to provide this information into the federal database. It's a good system. Compliance with it, however, has been slow. We feel that this bill, through the provision of transmitting this data directly to the state and then from the state to NMVIDIS, is going to help with the compliance. With that, I urge your due pass on House Bill 309 and glad to answer any questions. Thank you, Mr. Chairman.
Thank you. You may want to hold on a minute. We have a question from our most senior member of motor vehicles.
Yeah, as we talked about, it's a good move in the right direction, but the case I had, I want to ask you, would it have been fast enough to have done anything about this? This person from my district works in East Point, and he had his truck, which is worth far more than $1,000, parked next to his business. It was stolen and taken over to the scrap place and scrapped, and then that night, as soon as he missed his vehicle, he turned it to the police. I guess I was surprised that there's no requirement on the scrap dealer to check and registration or something with the state or somebody to keep that from happening.
Yes, sir.
What would happen in that case?
What happens is now, as a result of the requirements that were put into place in 2007, there are very specific record-keeping requirements on either that scrap processor or a parts dealer like ourselves. So we have to get the information on who sold that vehicle. They sign, either provide a title or the affidavit that's required under that provision. Falsification of any of that information is a felony in and of itself. There is, again, for the first time, a clear paper trail of what happened to that vehicle. Does it prevent a vehicle from being stolen? I wish it would. It doesn't. But what we can do is make sure that the perpetrator of that crime, the thief that took that motor vehicle, can be effectively prosecuted. And there have been a lot of good prosecutions as a result of this paper trail that's now been established.
But the only thing that the truck owner has available then is to sue that scrap dealer? Would he have a case there?
He would certainly have a case against the person who stole the vehicle. He would also potentially have civil recourse to whoever bought the vehicle. So that is potential recourse.
Okay, thank you.
Sure.
Any other questions from the committee? Thank you, Steve. Lieutenant
Mike Giuliano, sir.
And I will tell you, brevity means a lot to this committee. I see that you're in favor of this bill.
Yes, sir, I am. I'm Mike Giuliano. I'm a lieutenant with the Atlanta Police Department, been on 22 years. I host the metro area copper theft task force as well as host the Metro Burglary Task Force meetings. Last year, we noticed that although our auto thefts have been consistent in numbers, for Atlanta roughly 5,000, we're recovering less than 1/3 of the vehicles stolen. So in August, talking to other police agencies and kicking around the table at the recycling meeting, we're wondering where these vehicles are going. Steve was nice enough to invite us out to his location to explain the scrap process, and we realized that there was some shortcomings in the current law. If an investigator is investigating a stolen vehicle and the vehicle is taken off the interstate and brought to another jurisdiction recycler, the investigator has no database that he can query to find out where this vehicle has been scrapped or turned up at. This law, we feel, would close the gaps or do away with that problem. Corporal O'Neill from the Fulton County PD is standing behind me here. He did a detail that was on the TV about 2 weeks ago. He went to a local East Point recycler, wanted to know all the vehicles that were taken in the last 3 months. Ran all the tags. He recovered 267 stolen vehicles and secured arrest warrants for 47 individuals. Again, there was no central database. If he didn't take the initiative to go to the recycler and query, who was doing it, there's no way an investigator can query where these vehicles are going. So I appreciate your time. Law enforcement does support this bill. I think it will, not maybe, it's unfortunate the story that you told about the vehicle of your constituent and everything, but hopefully through this we'll be able to put him in jail and there won't be another victim of a similar crime.
Any questions from the committee? Thank you for taking time out of your schedule to come in here today.
Thank you, gentlemen.
Sergeant Howell.
Thank you, Mr. Chairman. Mr. Chairman. Sergeant Mike Howell with Douglas County Sheriff's Office. We, too, are in favor of this bill. We experience a substantial amount of auto theft, and as part of that auto theft, we're only recovering about 1/3%, and most of those vehicles are 12 years or older. We have 2 scrap yards in our county that we monitor fairly frequently. We do recover cars from them. Unfortunately, like the gentleman here said, that it was already taken there and crushed. That's a lot of times we find out after the fact. We also we learn after the fact of other jurisdictions where we don't have access to, a database we don't have access to, that they have recovered our cars by checking their intermittent scrap yards. We recover cars from there too. We think with a central database that we'll be able to reduce that and increase the numbers and decrease the chance of another victim. Thank you.
Thank you, sir. Any questions? Chip Copeland. Brevity, Chip. Brevity.
You got it. Thank you, Mr. Chairman and members of the committee. I'm Chip Copeland. I'm president of the Georgia Recyclers Association, and the Georgia Recyclers are proud to continue our partnership with law enforcement in the effort to stop metal and auto theft, and Georgia Recyclers Association supports this legislation.
Thank you, Chip. And last but not least, Tim Mitchell with the Department of Revenue.
The beneficiary of this legislation.
I understand.
In concept, the department supports it. It's a great idea, but we would like to point out 2 things. One is that we're currently in the initial stages of updating our gratis system, or the title and registration system. Part of the overall or overreaching goal is to invite people like Steve Levitan and all those to come in and tell us what they need, and so we can incorporate it in the future. For the committee, and I know I'm boring Chairman Rice, but our current system is a COBOL system. And what that means is to make one change requires us to do a lot of data entry. So what the department would like to see is that maybe the effective date be moved back a little bit to allow us to incorporate it in the new system and to address that need. One thing we would not like to do, obviously, is to spend money putting in a system that we're probably going to cease using here within the next 18 months.
Questions? Tim, did I understand you say a cobalt system?
COBOL.
That's what y'all, COBOL, that's what y'all
Currently
have.
have.
Right with?
Yes, sir.
Is that the same one that went out of style 20 years ago?
Yes, sir.
Or longer?
That's the one when they first started, yes, with Fortran and the rest of it. Yes, sir. Yeah, you remember that? Yeah.
So, question that I might have is, how long do you think it would take for y'all to be able to implement this?
With the new or the old? The old system, given the fact that we are currently working on the Nembetis project itself, you're probably looking, I think what they told me was around 6 to 8 months. Under the new system, the vendor's telling us that we could probably have a basic system up within 12 to 14 months. Depending on how many do loops and whistles gets put on it, could extend it to 18 to 24. But the idea is to get the basic gratis system going as soon as possible.
Really?
This is a good idea. Don't get me wrong. I mean, it's a great idea, but
I mean,
I'm just pointing that out to the committee that we have something else already in.
Well, the question I would have, it is a good idea, and it's a good legislation that backs this good idea up. But we're talking about a difference, and this has an effective date of July
1st,
1.
2011. Just a suggestion, sir.
Well, I mean, I understand that, but we want to, if we pass something out, we want it to be effective. We don't want something to be, we don't want to give the executive office a reason not to sign the bill.
Well, the one thing,
even though I don't think that's near as much of a question as it was a few months ago.
I did talk to. Thank you, sir. I did talk to a few of the folks that are behind this bill, and I mentioned to them that the department, as an interim, would go back through its processes to see if there's a way to alleviate the delays that have occurred. Part of it is just looking to see if there's maybe a way we can do it through PDF files. It's still going to require somebody to enter it. I understand that, but there might be a few things that we can do that would expedite and override the delay. But again, that's something I'm going to have to sit and talk to the motor vehicle director about, the commissioner.
Okay. Do we have any questions from the committee members?
It doesn't seem, and perhaps I'm making this too easy, but it doesn't seem to me that it is going to be that difficult to implement the minor amount of information that's going in with these vehicles. I mean, if you could, I mean, I deal with spreadsheets all the time. If I can put this in a searchable spreadsheet and bingo, I've got the information. It doesn't take a rocket scientist to put this stuff together unless you can convince me otherwise.
Someone who's been around as long as COBOL, Doug Hooper, who's been with the system and worked with the chair, and maybe he can answer those for you.
Thank you. Douglas Hooper with Tax Law and Policy. The database we have now written in DB2 is, and understanding your question about spreadsheets, that data in a spreadsheet still has to be converted to the language COBOL can understand. Those are some of the roadblocks the old system has with newer technology. The Nembetis system we're developing today has moved us toward where we're able now to take the data we have in our system and since the earlier this year begin updating it into the national system. We've been doing that since first or second week of January. Currently, we're taking the system now so we can do batch requests to the system as well. So we're moving forward with Nembetis to keep that database as current as possible. But getting data into it right now is still a manual process.
Maybe just one other point, and what we're trying to do is move off mainframe, so we're going to more server. So what you're talking about would be possible, but given the fact that we're going to have to convert it back to COBOL is going to be a problem. someone's still going to have to enter the data.
Any other questions, Rick?
I just have one comment. The day that we eliminate your computer system, I hope you load it in one of the back of one of those pickup trucks you take off, and I want to be there when you crush every one of them. I've been talking about how antiquated the system that you are having to deal with for a long time, and I appreciate even the thoughts that that's going to change in the not too distant future. Thank you. That's just
Any other questions from any of the committee members? Chairman Rice, we've heard what Revenue said. Do you have any? Would you like to give us your wisdom on this?
Well, Mr. Chairman, from one who knows what the acronym stands for, Common Business Oriented Language, COBOL, you'd have to go back some years to examine that in terms of whether that's wise or not. But the fact of the matter is that I understand the pressures on the department in terms of being able to come up with data. In my case, particularly data I've solicited, I understand that that's difficult for them. My druthers would be to, on this situation, would be to amend the bill on line 18 from $1,000 to $850 on page 1, and on the date of effectiveness, Mr. Chairman, I would like the opportunity to leave that as it is, and then negotiate that in a little more detail with the department, and in the Senate, when the Senate gets the bill, I'd like to reserve that to the time we get together on that.
All right.
So I also have another change that I forgot to mention. It's requested by the insurance organization. That's on page 3. At line 97, last line on the page. This has to do with the record that's given at the time the salvage transaction occurs. Insurance there are several insurance salvages where they truck the salvage vehicle to a yard, and they may not be the person that has the driver's license for that particular, as an owner of the car or the title. So they want to strike seller on line 97, and put in seller or seller's representative. So that would include the person who's actually driving the truck over to the yard on an insurance salvage.
Do you want to give us the rest of your amendments that you want to do?
Yeah, the only other amendment, Mr. Chairman, is on line 18, and that would be to strike 1,000 and insert 850.
Mm-hmm. Would that change also be on 32 and 42?
Yes, any place that it's found. I'm sorry, 32 and 42. I think those are the only places it's found.
Mr. Austin.
Mr. Chairman, thank you. Let's go back to line 97 where we're popping in that or seller's representative. Is that a commonly used enough phrase that someone reading the law would understand? Because, I mean, I could take a car someplace and be a seller's representative, and so I wonder if that is too vague. That, somebody could walk in off the street and go, I was the representative of the seller, and here it is.
Well, I'll let Mr. Ask Steve to comment on that.
Can I comment on Steve's behalf? Bobby
Oh,
Potter.
I'm sorry.
That's all right. Bobby Potter on behalf of State Farm. We met with all of those folks, including the police departments involved this morning, and that was the suggestion that the person that is there with a driver's license. So it's not the seller. If State Farm owned that's salvaged. We wouldn't have a driver's license, but our representative would, whoever that may be. And that's what they want to scan, photocopy, and keep, is something that that person has. And that if it is stolen, that could begin the track.
Gotcha. I see it now. Thank you for the clarification. Gotcha. Thank you, Mr. Chair.
Did you wish, Lieutenant?
I understand.
I was just going to piggyback on what he said. We just want a starting point where to start the investigation. So we have a driver's license, we know where to start.
And this would give the proper chain of evidence in case anything. All right. Any other questions from the committee? All right. Well, at that point, if there's no questions, I think this would be the proper time. Is there a motion?
Move to pass as amended.
We have a motion with the changes. Rick, did you have a question?
It's taken care of. We're good.
Good. All right. As a committee substitute, I presume.
Yes.
All right. We have a motion. We have a second to pass forward House Bill 309 as a committee substitute with the changes that have been brought up. Any questions, comments? If not, all in favor say aye.
Aye.
Opposed? Thank you, Mr.
Thank you,
Chairman.
members of the committee. Appreciate all the hard work today. Did a great job of
I think we
making the
still
changes.
we still have a bill committee, House Bill 253. Welcome.
Good morning, Mr. Chairman. You want me to go ahead and get started?
How are you this morning, floor leader?
Running already. Running already. House Bill 253 is a bill that I actually carried a few years ago, and after some conversations with the previous administration, they did not look favorably upon. This administration does look favorably upon, and this is allowing the State Patrol, the Department of Public Safety, to go back and manage the buying and selling of their pursuit vehicles. They have done this in the past. We're simply going back to that. The main reason, and just giving an overview, and we'll be happy to answer questions of it, the vehicles used in the State Patrol are unique. They're not like the others that the OAS deals with, especially because of their mileage, their running times, what they're doing, and all of it just that goes into a pursuit vehicle as compared to a vehicle that Revenue or somebody else may be using. So what we're looking at here, this also in time allows them to sell them at a earlier mileage, which provides safer vehicles for the road for the officers to use. It also provides a lower maintenance cost because once you get over 85,000, you're starting to add maintenance costs of $2,500 a year to some of these vehicles. That really, just in the end result, it allows us to, through our use of bond money, through other things, to provide these newer vehicles. They're able to then resell them and actually recoup some of the cost of the purchase itself, which in turn allows us to continue to purchase more vehicles. It really, in the long run, is not only a cost savings, but also provides us with a valuable asset for the Department of Public Safety to do what they need to do. The bill is very straightforward. You see it there. It's 2 pages. It simply strikes the language and allows the commissioner at their discretion to do that. And I have Colonel McDonough here, which is a privilege for me to look there and call him that. He is a representative us well, and we have to answer any questions. The biggest, again, the issues are under the rules. It can't do anything outside of what's not appropriated. This is not giving them bonding authority or anything like that.
Money's returned to the state treasury.
Money goes to state treasury. It's no constitutional amendment to this. It just simply goes back to the way it used to be. And we're not the only one. Most states do this in a lot of ways with their public safety, and also municipalities as well. They buy and sell outside their normal chain because there's such a recognition of difference. And we feel like this in the long run also provide better for some of our smaller departments in the state to be able to provide them with better vehicles at lower mileage and at a lower cost. So it's a trickle-down effect as we go. And I'll be happy to answer any questions, Mr. Chairman.
Very good. Colonel, would you like to speak? It's good to have you here.
Thank you, Mr. Chairman.
Been a while.
Well, it has been. This is a standard business model. For those that have been in the car business, you know there's a tipping point for the value of the car. And all we want to be able to do is sell the car before that tipping point, before we start putting money into vehicles maintenance-wise that we can't get out of it. My vehicle is a perfect example of that. We just put $1,400 into the rear end of a car that has 228,000 miles on it. That makes no business sense whatsoever. I think it's a matter of appropriation to get the cars and then manage them appropriately, and that's all we're asking to do.
Good. Any questions from the committee?
I have one example I'd just like to give, and I have the actual numbers here on there. We have troopers on the road right now who we're asking to risk their life doing what they're doing in cars that are 189,000 miles, 183,000 miles. And typically is what happens. These are typically our younger troopers getting these cars. So it just is a way to look at this. It's just a different way.
I don't think we have any questions from anyone in attendance. If they are, woe be you if you're willing to speak and opposed to this bill. Mr. Battles.
Move to do pass House Bill 253. Make a motion to do pass.
We have a motion and we have a second. Any questions? Any comments? All in favor say aye.
Aye.
Opposed?
Thank you, Mr. Chairman.
Sorry you got hung up behind
well,
Chairman Rice's bill.
Well, it's part of that thing in the rules this morning. We got here as quickly, and I do appreciate y'all's indulgence.
Not a problem.
Thank you much.
We appreciate State Patrol's thinking of themselves in public safety.
Y'all feel pretty good about that idea, getting 300 new cars.